in which your lordships are, my lord, examining the issue. My lord, the honorable president would like your lordship's opinion on that, my lords. And there are reasons. Your lordships are aware the opinion will be requested when a question has arisen or when a question is likely to arise. My lord, these are the two contingencies under which, my lord, inter alia, the honorable president can, my lord, seek your lordship's opinion on that. Please have a look at, my lord, how this question has arisen but will definitely arise. And I am showing the view in Tamil Nadu, my lord. Likely, I am conscious it's not an intra-court appeal, but it's a view decided and legal view your lordships can, my lord, as held in the 2G case, interfere with. My lord, please have a look at, my lord, first, page 12509, volume 5.31. We, my lord, examined this. We went to this.
The question is whether a petition under Article 32
or 226 would be maintainable in the context of the power or function, my lord. Power is a little harsher word. Function exercised respectively by the Honorable President of India and the Honorable Governor under Article 111, Article 200 and Article 201 of the Constitution of India.
An exercise by President or Governor
Respectively under Article 111 and 201 and by the Governor under Article 200. But this, my lord, was not, my lord, none of us assisted your lordships on this. And I am the only one, my lord, who is going to make submissions on this. Others, my lord, would not trouble your lordships, my lords.
What is the page that you have referred to just now?
12509.
That's it.
Para 367. Lord, PDF would be 336. In that volume, my lord.
Paragraph 367.
367.
Yes.
The honorable bench is pleased to summarize the conclusions. Kindly come to A. Because this will have to be examined, my lord. Otherwise, my lord, questions will keep on arising. Which question is already, my lord, put for your lordship's kind opinion. Your lordships, may I read, my lord? A. Where the governor reserves a bill for the consideration of the president in his own discretion and contrary to the aid and advice tendered by him by the State Council of Ministers, it shall be open to the state government to assail such an action before the appropriate High Court or this court. Such a challenge can broadly be made on the following grounds. So first, it can be a 32, it can be a 226 petition, and these are the grounds. Please read. Where the reservation is on the ground that the bill is of a description falling under the second proviso to Article 200, it may be assailed on the ground that the bill or any provision thereof does not so derogate from the powers of the High Court so as to endanger the position which the court is designed by the Constitution to fill. The governor, while reserving a bill on this count, shall be expected to provide clear reasons and also point to the specific provisions of the bill which, in his opinion, attract the second proviso. This is, my lord, difficult part. This question being purely of a legal nature would be completely justiciable. My lord, meaning thereby the legal view is whichever is legal question is justiciable question. I'll come to that, my lords. And the competent court would be, after a proper adjudication, fully authorized to approve or disapprove such reservation by the governor. If such a challenge finds favor with the competent court, then, subject to other considerations, it would be a fit case for the issuance of a writ in the nature of mandamus to the governor for appropriate action. I'll come to that, my lord, whether a writ would lie against the governor, my lord, under the scheme of the constitution. When your lordship examines governor's function or exercise of power under 356, my lord, presidential rule, failure of law and order, Article 356 provides for a contingency. That if there is a failure of law and order,
Conditions on which the power can be exercised.
power can be exercised, and your lordships would not be issuing a mandamus to the governor. Your lordships would be setting aside the order whereby the president's rule was imposed. Lord, further, then Roman 2, where the reservation is on account of the bill attracting any provision of the constitution whereas the assent of the president is a condition precedent for the proper enactment and enforceability of such a bill as a law, such as under Article 364A2, or for the purpose of securing any immunity or overcoming any repugnancy that may exist qua a central legislation, then the governor is expected to make a specific and clear reference to the president, properly indicating the reasons for such reservation and inviting his attention, that is president's attention, as described in Kesare-Hind. Such a reservation can be assailed by the state government if the reference made by the governor either fails to indicate the reasons for such reservation as discussed above, or, please mark, the reasons indicated are wholly irrelevant, mala fide, arbitrary, unnecessary, or motivated by extraneous considerations. So not only petition would lie on these grounds, and when petition is filed, these are the considerations, even unnecessary, that it was not necessary. We feel it was not necessary, so we substitute our decision to that of the governor and direct the governor by a writ of mandamus. Further, then such a reservation would be liable to be set aside. This question being purely a legal nature would be completely justiciable, and the competent court would be, after a proper adjudication, fully authorized to approve or disapprove of such reservation by the governor. Meaning, thereby, my lord, again, law is, if something is legal, it is justiciable. If such a challenge finds favor with the competent court, then subject to any other considerations, it would be a fit case for issuance of a writ in the nature of mandamus to the governor for appropriate action. So, my lord, it is kind of a advance ruling, my lord. Now, my lord, kindly see 12582 or 578, 12578. One two five seven eight. My lord, I'm sorry, 12513, my lord, if I kindly, my lord, see 12513. My lord, there is a time limit prescribed, and my lord, kindly see 12513, my lord, Roman 5. That's my lord Justice Narasimha gets, my lords get. Where the governor exhibits inaction in making a decision when a bill is presented to him for assent under Article 200, and such inaction exceeds the time limit as has been prescribed by us in para 250 of this judgment, then it shall be open to the state government to seek a writ of mandamus from a competent court against the governor, directing expeditious decision on the concerned bill, as is the mandate of the Constitution. However, it is clarified that governor may successfully resist such a challenge on providing sufficient explanation for the delay caused. My lord, governor can't even be called upon, my lord. My lord, here, my lord, in substance, my lord, the court doesn't use the way in which, my lord, I am describing it, that Mr. President, you decide within 3 months. You better give your reasons, my lord. I have shown that. And the state government, if she doesn't do it, come to us. That, my lord, with profound respect, is not the constitutional scheme. A, 32 does not lie. 2, mandamus cannot be issued. And 3, it is not justiciable. Every question which is legal is not justiciable. Now, my lord, come to page 12578. And, my lord, this will have a far-reaching ramification. Therefore, my lord, after considered debate, my lord, at our end, my lord, the Honorable President decided that it's better that we know what is the legal position, and therefore we must request for the opinion of your lordships. Lord, 12578, para A, Roman 1. These are also, my lord, the penultimate, these are the final directions. Where the reservation is on the ground that the bill is of a description falling under, my lord, that is, my lord, the same thing. And, my lord, I'll not, same conclusions, my lord, are repeated. My lord, in the final chapter, my lord. I'll just, my lord, place my short note. And my lord, I can assure your lordships, I'll not read everything. But copies are given, my lord. I have prepared this. Lord, it would be volume 1.8. Lord, volume 1 should have been the Learned Attorney General's volume, but since mine was filed first in point of time, Lord, the numbering is accordingly given. Lord, I'll just broadly indicate and read only those paras which would assist your lordships, my lord, directly. Everything, my lord, is there, my lord, for your lordships to consider, and everything will assist your lordships. But, my lord, considering that I am, my lord, raising this issue with your lordship's permission at the end, and nobody else is going to, my lord, raise this issue, my lord. This is our collective work, my lord, which I am presenting before your lordships. My lord, first, whether a writ petition under Article 32 would lie at the behest of the state government, my lords. Lord, there are two objections, and based upon which, my lord, we request your lordship's opinion whether your lordships would entrust or empower the state government to file a writ petition, my lord, because you have to seek source of your right. This is the court given right, my lord, that you all right, you come to us. My lord, there are two objections. A, 32 lies when there is a violation of fundamental rights, and the state government as a constitutionally formed body per se cannot have fundamental rights. It may represent fundamental rights of others, but otherwise the scheme of the constitution is state government is repository of functions which is to protect the fundamental rights of everyone. Now, a similar question arose even by an individual. My lord, what happened was the house was prorogued by the speaker, which was illegal. And one member of parliament approached your lordships under Article 32 of the Constitution, and the question squarely arose whether a 32 petition would lie. My lord, please come to, my lord, page 3 of my note. My lord, the bottom is the pagination. My lord, your lordships may bear one factor in mind, my lord. Kindly, my lord, this was, my lord, highlighted, but my lord, I feel, my lord, it could not be highlighted as much as we wanted to highlight it. My lord, there are chapters under the Constitution. Your lordships would find chapter 200, article 200 in the chapter which starts with legislative procedure. So please come to 196, my lord, article 196. Just above that, heading, my lords. 196, provisions as to introduction and passing of the bills. I'm not reading it. The legislative process starts with introduction of the bill. Obviously, it's a part of the legislative process. Then it goes up to Article 200. The legislative process culminates, ends when the governor discharges one of his choices out of the four, or the honorable president, on being reserved, exercise the proceedings, exercise the choices under Article 201. So Article 196 to 201 is a part of the legislative process. It has as much sanctity as proceedings in the House before in the House. And thereafter, the new chapter starts, procedure in financial matters. When a bill is involving issues with regard to financial bill, etc., etc. So, my lord, my first respectful submission for your lordship's assistance is that it is a part of a legislative process, and the question would be, can any part of it be subjected to writ jurisdiction on the ground that fundamental rights are violated? Please have a look at page 721. The bottom pagination internal is 3. Ramdas Athavale versus Union of India. It was held that the validity of the speaker's decision adjourning the House sine die and later directing to
Where
resume.
are you reading?
Lord, I'm sorry, page 721. My note,
Yes.
top pagination is 721.
Ramdas Athavale.
Ramdas Athavale. What is 5? Yes, madam. It was held that the validity of the speaker's decision adjourning the House sine die and later directing to resume its sittings cannot be inquired into on the ground of irregularity of procedure. The relevant paragraphs reads as under. It is equally well settled that Article 32 of the Constitution guarantees the right to a constitutional remedy and relates only to the enforcement of the right conferred by Part 3 of the Constitution, and unless a question of enforcement of a fundamental right arises, Article 32 does not apply. It is well settled that no petition under Article 32 is maintainable unless it is shown that the petitioner has some fundamental right. In so-and-so versus so-and-so, this court has made a pertinent observation that when a person complains and claims that there is a violation of law, it does not automatically involve breach of fundamental right. My lord, similar judgment is, my lord, I'm not, my lord, reading it, but where they say even private party cannot come directly to the court under 32, that there is a violation of law, because you will have to show
Unless there is a violation.
of fundamental rights, my lord. My lord, kindly see, Lord, one provision of a constitution can bar jurisdiction of the High Court or the Supreme Court in another provision of the same constitution. Lord, that question arose when state of Karnataka came here in a 32 petition with regard to water dispute. And this honorable court was pleased to say that we have a separate article, Article 262, for dealing with intrastate water disputes. And therefore, you cannot come under 32. My lord, please come to 722. My lord, I am also saying 131 would also not apply, but I would, my lord, come at my lord, at the end. My lord, please see, there are, my lord, this is Atmaling Reddy versus Union of India, where he was a man, my lord, according to, my lord, it appears, my lord, sponsored by, not sponsored, but put up by the state. Article 131 of the Constitution, which enables the central government or a state government to institute a suit in this court on its original side in certain cases, also cannot be invoked in interstate water disputes in view of Section 11 of the Act. In other words, the provisions of Article 131 of the Constitution have to be construed harmoniously subject to provisions of Article 262 of the Constitution. A petition under Article 32, hence, cannot be entertained by this court. Well, this is only for the limited purpose that one constitutional provision can also bar jurisdiction under Article 32. Now, my lords, may kindly come to para 7. Lord, the possible argument that we are coming here in a representative capacity because we represent the people. It's a quite possible argument and a permissible argument. They do represent the wish of the people. But question is, would that entitle them to invoke your lordship's jurisdiction under Article 32 of the Constitution? Because as I have already said, the solution lies elsewhere. 32 would not be maintainable. I am only on maintainability. Please have a look at para 7. It is submitted that Article 32 is a remedial provision meant for enforcement of fundamental rights under Part 3. A state is itself the state within the meaning of Article 12 and is the bearer of constitutional duties, not the holder of Part 3 rights. Therefore, a state cannot maintain a petition under 32. For the same reason, a state cannot use 32 to litigate fundamental rights in a representative capacity. Article 32 requires the petitioner's own Part 3 right to be in issue. So that's how the article is worded, that petitioner's fundamental right. My lord, your lordships have exempted this only when the concerned petitioner is unable to approach. My lord, workers,
On account of social and economic disability.
economic, my lord, and not to the government. Government cannot come. It's the duty of the government to protect them. Some non-governmental organization comes, some individual in a representative capacity comes. Now, please, my lord, come to, my lord, directly page 725. My lord, I have cited judgments, my lord. I'm not reading them. Relevant part is highlighted.
Sorry. Yeah. So,
Yes, my lord, 725. My lord, I have said that, my lord, kindly, I'll read para 13, my lords. In view of the above, a state which does not have any fundamental rights cannot file a petition under Article 32 for any purpose whatsoever. Permitting states to file Article 32 would amount to turning the scheme of Part 3 on its head. The center-state relationship is governed by Part 9, 10, 11, 12, and 13 of the Constitution. The disputes between the governments are dealt with in Article 131 of the Constitution. A state government or even the central government cannot invoke Article 32. But this would be very, very relevant. Kindly imagine a converse situation. Look, there is a law and order situation in one particular state, and such instances have arisen. My lord, I am not giving a hypothetical example, but without naming the state, where there is eruption of my lord, violence. The local police is unable to contain violence, either because of inefficiency or because of inadequacy of the force or for various, my lord, other reasons. And if the central government says, and which it can say, my lord, under the Constitution, that you deploy paramilitary forces for protecting the fundamental rights of the citizens, and the state refuses to do that. Lord, I am putting a question to myself, can the central government file a petition under Article 32 seeking a direction of your lordships, directing the state government to deploy paramilitary forces, my lord? My answer would be, my lord, in the negative. It cannot be done. Yes.
But nobody is to.
No, he is rejecting my submission, my lord. So I am saying, please don't do that. You will oppose every submission, but not now. That's simultaneous. Lord, now, my lord.
Yes, proceed.
He can never, my lord, disturb me without my consent. I refuse to be disturbed. Lord, page 725. Lord, bottom, Lord, this is.
Why are you getting disturbed if you can't be disturbed?
No, I am just telling him that please don't do this. 725, my lord.
Yes.
Lord, this is American law, my lord, which I generally do not cite, but please have a look at, my lord, this. And therefore, I have not quoted in extenso.
Para?
My lord, at the footnote of page 725.
Okay.
In American constitution law, it is settled law that the states cannot assert the rights of their citizens as parents patria and approach the Honorable Supreme Court of the United States under its original jurisdiction when the defendant is the federal government. My lord, states there, my lord, are quite independent. It's not a part of a federal whole. They have their constitution, they have their separate flags, they have their separate Supreme Court. They say that these are federal issues between the state and the center, and we would not kind of work as a headmaster between two fighting students. My lord, in main submissions, my lord, I ignored that, my lord, but we have cited American cases also, that where the federalism is of a different nature. There were questions of deployment of forces, my lord, in American courts. But they say that you cannot come to the Supreme Court for this. These are federal issues decided politically. We would steer away from such issues being examined at the judicial level. Now, my lord, para 17, I have said, my lord, and I'll orally paraphrase, I will not read it. My lord, I am coming now to Article 226. My lord, what would Article 226 entitle or empower the High Court to do? And let us examine each. Writ of habeas corpus, no question from in the facts of the case. Writ of certiorari it applies to, my lord, tribunals, quasi judicial bodies, etc. Writ of prohibition, when some statutory authority is discharging some function or constitutional authority is discharging some statutory function, non-constitutional function, in a manner which it should not, then it will be prohibited. The question cannot arise in the context of Article 111, 200 and 201. Quo warranto is not a situation, then only remedy left is mandamus. Now, kindly examine a situation, my lord, and take each of the options available to the governor. If he grants assent, my lord, can someone who is aggrieved by grant of assent, state would not be aggrieved, but someone aggrieved by grant of assent, can it challenge before your lordships, and can High Court issue a mandamus that assent is bad? Because then you are examining a law.
No, that is a totally different situation.
Then you will
Because
say the law.
Once a law, after the assent is granted, the law stands enacted.
So the law will be challenged, not the assent.
So the validity of the law
Yes,
can be challenged
I'm grateful.
on the grounds parameter available to it.
Correct.
But that's a different situation. But the question is when the governor, when the honorable governor sits for a bill passed by legislature, and maybe on the second occasion also, can he just sit on for time immemorable?
I have already argued that, my lords, because justification will not confer jurisdiction. If it is not justiciable, it is not justiciable. My lord, and therefore, please, my lord, at the cost of repetition, I am urging few facts which are, my lord, only few facts are before your lordships. They, my lord, chose not to, my lord, undertake any political process. Otherwise, my lord, every state.
The Constitution debate show that earlier, before, as soon as possible, the word used was within 6 weeks.
Correct, in the proviso.
And thereafter, one of the honorable members suggested, you don't look at that side. You are addressing us, not them.
No, he is behaving
According to him, you are
like
Vishnu Kamath.
and he is so much agitated that he replies to every contention sitting there in my hearing.
He has no idea as to how this court functions.
Anyway,
I know, my lord.
that's.
I know, my lord, because I would not prepare.
Anyway, we are not supposed to resolve that dispute here.
No, my lord. That's
We are sitting in a presidential reference.
Lord, my learned friend is right.
At 1 o'clock, both of you go for a cup of coffee and resolve it.
No, my lord, we can even have a meal. There is no difficulty. But I agree. I do not have any idea as to how the courts function because I do not make reels and make it viral that how beautifully and
let's
brilliantly
stop at
I
that.
argued this. But leave it at that, my lord. It would not be proper, my lord, to be personal.
As you see,
Now, my lord, your
if you
lordship.
see the debate, the earlier suggestion was that it should be within a period of 6 weeks. Then it was found that the time bound rule may not be appropriate, and therefore it was made as soon as possible. And one of the members also made a in discussion said that the very purpose of using the word is as soon as possible means immediately,
Earliest,
without any delay,
at the earliest.
at the earliest. And therefore the suggestion was as soon as possible, but not later than 6 weeks.
Understood, my lord. I bow
That
down.
also was not accepted.
I bow down, and
So
therefore,
therefore, the constituent members of the Constituent Assembly had what had they in their mind was that the Honorable Governor would
is
look at the issue
expected to
with
decide
the
at the earliest.
expected exigency.
Correct.
And if that was the intention of the constitution makers, can we ignore that?
My lord, again, my lord, with respect, my lord, I'll put it a little, my lord.
You won't disagree that while interpreting the provisions of the constitution, we can go into the constitutional debates.
Certainly, I am relying upon, they are relying upon, everyone is relying upon. There cannot be any argument. But, my lord, the example which your lordships are giving, and very rightly giving, would mean that the governor is expected to react immediately. But we do
Not
not
immediately, but within a reasonable period.
reasonable period, my lord. I'm not on the time limit. But sometimes, my lord, what is that time limit, my lord? That depend upon facts of
depends
each
on facts.
case.
It will
And your
depend
lordship-
upon circumstances.
Yes.
So whether the court would not be justified to find out whether the circumstances were correct or not, or the governor, I won't use the words which are used by the division bench, but was not justifiably or was not justified in sitting over the bill for 6 months or 1 year.
My lord, again, I'm going back to my earlier argument, and I'm not going to repeat it, my lords, that one constitutional co-organ not discharging its duties or not discharging in time will not confer jurisdiction on another constitutional organ.
Yes, we recollect your argument that if this court doesn't decide a matter for 10 years, would the president be justified in issuing an order?
It was an example given. It was not, my lord, an argument that justification cannot confer jurisdiction. Lord, it is expected, and if that happens, the solution lies outside the court rather than advising the state to file petitions. That's, my lord, the respectful submission. Now, my lord, what would your lordships do? My lord, suppose it is withheld. If it is an assent, your lordships would examine the bill. But there is a possibility that assent is granted. Forget the delay part. I'm not on delay part. Assent is granted immediately. Someone is.
Then it becomes a law.
Give me a minute more, my lord. It becomes a law, and law can be challenged on various grounds: repugnancy, fundamental
On
rights.
limited grounds.
What,
On the limited grounds that are available.
whatever, my lord, it's a law is settled, and I'm not going into it. But, my lord, there can be instances where, kindly, my lord, consider this argument a little minutely. Lord, suppose the outgoing ministry at the fag end of their tenure passes a law hurriedly. I'm giving an example. The governor grants assents. The new ministry comes and new ministry challenges the assent. But I'm giving a hypothetical example. What mandamus the court can issue? Would the court be able to say,
The new government comes, it's always available for the legislature to change the law.
I'll come to the second point. I'll come to the second option. My lord, suppose the bill is withheld. And withheld means, my lord, as we have understood, it falls through. That withholding is challenged. And if your lordship finds, and if your lordship says that your lordship would have the jurisdiction, that it should not have been withheld, your lordships will have to necessarily say that we set aside the order of withholding and issuing a mandamus for the governor either to assent the bill or refer it to the president. Lord, the question for your lordship's opinion is, can such a mandamus be issued? Suppose the division bench says that even if it is referred to the president, a party can come here, the state can come here, not party. State can come here. That it is wrongly referred for the consideration of the president under the first proviso. Lord, would your lordships, my lord, I'm posing a question to myself in a 226 or 32, say that no, it is wrongly referred and therefore we set aside that order of referring it to the president and we direct by way of a mandamus to grant assent to the bill. Your lordships have said time immemorial, my lord, time after time, judgment after judgment, your lordships will not issue a mandamus to implement a particular law or make a particular law. Mandamus directing issuance or directing grant of assent would necessarily, inevitably mean that your lordships are directing making of the law. My lord, in AK Roy, your lordships have said that even if the constitutional amendment is passed by the parliament, not brought into force, a petition was filed, the court said, this is not our domain. We cannot ask them to implement this particular law. My lord, this position would be no different. Your lordships, if there is an availability of mandamus, will have to say either under Article 32 or 226 that I set aside the order of withhold, meaning thereby you decide it, you grant assent, or you refer it to the president, and that reference also is a subject matter of challenge before this honorable court, and the states would be advised to file a petition rather than taking any other constitutional option available. So, my lord, by very nature of the function and the position of the governor, the nature of the power conferred under Article 200, my lord, a writ of mandamus cannot be filed, and therefore 226 will not lie, my lords. That is, my lord, my respectful submission. My lord, in this context, my lord, I have cited laws that your lordships were, my lord, approach that direct the government to make rules, direct the government to make this law. Your lordships refrain from doing that. That's not the domain of the court.
No, we even refrain from entering into the policy matters.
Exactly, my lord. Even administrative, executive policy decisions. But here your lordships will have to say that governor who cannot be joined as a party, who cannot be called upon to explain, the my lord, division bench legal view is that governor will have to come and explain that what was the delay, why he referred it to the president, what is the reason for withholding. My lord, Article 361, my lord, becomes nugatory, my lord, if your lordships accepts the state's power to file a petition, my lords. My lord, now kindly see, lord, in SR Bomai, my lord, I'll read only 2 paragraphs and I'm not doing anything further. But please bear one distinction in mind.
You are saying all such directions can be given under 131?
No, my lord, I'll answer that immediately.
Therefore, the issue of forum is irrelevant.
No, my lord, I'll just answer that question.
Is there a forum at all for that?
Well, that's my case. It's not just issue.
No forum. The issue of whether 226, 31, 32 was all irrelevant.
Correct, my lords.
What's the
And
matter?
I'll answer your lordship's question on 131. Why I say this? I'm sorry, my lord, the Chief Justice is reading something.
Yes,
But 131, why it would not lie? But 131 is a provision where your lordships examine and adjudicate a dispute between Union of India and the state government. Here, one party is the state government. But governor is not Union of India. He is not a representative of Union of India. He represents the Honorable President of India. And therefore, any dispute between the state government,
how do you say that he doesn't represent the government of India?
no, he represents the President of
The government of India, the executive authority vests in the president.
Lord, constitutionally speaking, he represents the state. He is head of the state executive, representing
As a representative of the central government.
President of India, my lord. That's
No, the constitutional debate says that he is a vital link between the central government and the state government.
no. Kindly, my lord, have a look at, my lord, the provision. My lord, 155. Kindly,
So if you go through the constitutional debate
yes,
as to whether there should be a governor or should not be governor. So the framers of the constitution found that the governor has to be there so that a vital link is provided between the state government and the central government.
kindly look at it from a different angle. I'll show 155, but a slightly different angle. Is the president under Article 200 bound by the aid and advice of the central government? The answer is no. There are only 2 contingencies.
Central government, the president would be bound by the aid and if you...
I'm on governor. Right now, I'm on governor. But the governor can either decide based upon the aid and advice of Council of Ministers of the state or in his own discretion. He may represent the central government in a broad sense as understood in the Constituent Assembly debate. But he is appointed by the President of India and he is reporting and answerable to the President of India. And there are several constitutional functionaries who are appointed by the President of India, but they do not represent the central government. Please have a look at Article 155. Lord, I am putting a question little differently. Suppose the governor's action is under challenge. Can the central government come here and start defending the governor? Cannot. Lord, in most cases, it is the state government which appears and defends the governor. And this is the constitutional reason behind it. Lord, we are not on A situation or B situation. Lord, I am just assisting on a constitutional scheme. Lord, 155 says, the 154 first, my Lord, the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him. Then, my Lord, 155, the governor of a state shall be appointed by the president by warrant under his hand and seal. Lord, what is envisaged is that there would be a person who will deal with the national policy vis-a-vis the state level policy. But he is not the same thing as Union of India for the purpose of Article 131. Article 131 is central government versus state government dispute. Dispute regarding the boundary, dispute regarding the powers, dispute regarding the allocation of funds, etc., etc. Directly central government, directly state government. Because if we, my Lord, extend this logic, then even CAG is, my Lord, appointed by the President of India. Election Commission is appointed by the President.
Ishwar Prasad one,
Yes.
question was slightly answered,
Yes.
saying that the actions of the government, of course, there is an immunity, but if at all he needs to answer, that answer will come through the government. Rameshwar Prasad one, not two.
Yes, my Lord, but the government of the state. Because he heads the state. My Lord, I kindly appreciate, my Lord, he can't be joined. If a mandamus were to be issued, he will have to be joined, then we will be violating Article 361. And who will defend him? The state may not, because the state is the petitioner. Central cannot, because I can't come and say that, no, he's my representative. He did it at my behest. No, that's not the constitutional scheme. Lord, kindly see, my Lord, and the question of justiciability is a separate question, my Lord. But now please come to, my Lord, I'll, my Lord, at the end read only few paragraphs from Bomai. But bear, my Lord, but first, my Lord, I'll read few paragraphs from Bomai. My Lord, kindly bear one factor in mind. Bomai was a case where the governor's action under Article 356 of the Constitution was impugned. Article 356 has an inbuilt condition incorporated. When can you invoke? When there is a failure of law and order. And therefore, your lordships had a test to apply whether the governor's decision fall within this constitutionally framed condition under Article 356 or not. It was not, my Lord, a constitutional decision in the sense in which, my Lord, we are respectfully submitting under Article 200. Now, my Lord, kindly have a look at, my Lord, only few paragraphs, my Lord. My Lord, volume number 5.14. My Lord, your lordships may first, my Lord, take only paragraphs, my Lord, I am giving. I'll read 2 or 3 paragraphs.
Volume
My Lord, volume
14.
5.14.
Page.
My Lord, it starts at. Lordship, give me a minute. 5478.
5478.
Lord, kindly note the para numbers. I'll read only 2 or 3, but all are, my Lord, relevant. Lord Justice Ahmadi, para 32 and 35.
Yeah?
32 and 32 TO2 35. Then Justice Verma for himself and Justice Yogeshwar Dayal, para 40 to 49. Then Justice Sawant for himself and Justice Kuldeep Singh, para 59, 60, 62, 74, 83, 86, 96, and 153. Then, my Lord Justice Ramaswamy, para 198, 201.
One minute.
I'm sorry, my Lord.
Yes. Mr. Ramaswamy?
Para 198, 201, 211, 256-258. So Justice BP Jivan Reddy has expanded the scope of this court's jurisdiction, my lord, and said that it is amenable and there is justiciability, my lords. That is para 331, 372.
One minute.
I'm sorry, my lords.
Based.
Lord, 331, 372 to 376. Lord, they are all extracted in our main note at page 305 to 308. But please read, my lord, only one paragraph of Justice Ahmadi. It's a majority view. Lord, kindly come to page 5558. Lord, this was again, my lord, at the cost of repetition, a case of 356, where there was a binary. You can appoint or you cannot appoint precedence rule. Why? For what reason? What should be the ground? Failure of law and order. Here, my lord, we are dealing with a situation with multiple options and multitude of contingencies under which, my lord, those options are to be exercised. Lord, 35, Lord, somewhere from classitum G. The expression otherwise, your lordship gets, my lord?
Yes.
The expression otherwise is of a very wide import and cannot be restricted to material capable of being tested on principles relevant to admissibility of evidence in court of law. Now, please see, it would be difficult to predicate the nature of material which may be placed before the President or which he may have come across before taking action under Article 356(1). Because not only material provided by the governor, President can have other material also. Besides, since the President is not expected to record his reasons for his subjective satisfaction, but the article doesn't say you record your reasons. That is read for the first time, my lord, in Article 200. It would be equally difficult for the court to enter the political thicket to ascertain what weighed with the President for the exercise of power under the said provision. The test laid down by this court in barium chemicals and subsequent decisions for adjudging the validity of administrative action can have no application for testing the satisfaction of the President under Article 356. It must be remembered that the power conferred by Article 356 is of an extraordinary nature to be exercised in grave emergencies, and therefore the exercise of such power cannot be equated to the power exercised in administrative law field and cannot therefore be tested by the same yardstick. Please note this, my lord, and kindly underline, several imponderables would enter consideration and govern the ultimate decision, which would be based not only on events that have preceded the decision, but would also depend on likely consequences to follow, and therefore it would be wholly incorrect to view the exercise of President's satisfaction on par with satisfaction recorded by executive officers in exercise of administrative control. The opinion which the President would form on the basis of Governor's report or otherwise would be based on his political judgment, and it is difficult to evolve judicially manageable norms for scrutinizing such political decisions. It therefore seems to me that by the very nature of things which would govern the decision making under Article 356, it is difficult to hold that the decision of the President is justiciable. My lord, it's not on the question of jurisdiction of this court, it's justiciability. And my lord, para 34, your lordships can mark, there is a marked distinction shown in the judgment only. What is the distinction between judicial review and justiciability? Something can be within your lordship's judicial review power, but can still not be justiciable. Here, my lord, we are dealing with a situation where, my lord, the law as developed says that it's a question of law and therefore it is justiciable. Now, to do so would be entering the political thicket and questioning the political wisdom which the court of law must avoid. The temptation to delve into the President's satisfaction may be great, but the courts would be well advised to resist the temptation for want of judicially manageable standards. Therefore, in my view, the court cannot interdict the use of constitutional power conferred on the President under Article 356 unless the same is shown to be mala fide, because it was ultimately an administrative decision, not a legislative decision, where mala fides cannot be attributed. Then, my lord, after E, classitum E, I am also in agreement with Justice Verma when he says that no quitimate action would be permissible in such cases, etc., etc., my lord. Now, my lord, kindly come to para 216, Justice Ramaswamy. My lord, rest, my lord, I am not troubling your lordship, my lord. At 5664. Your lordship, my lord, got it? Para 216. To test the satisfaction reached by the President, there is no satisfactory criteria for judicially discoverable and manageable standards that what grounds prevailed with the President to reach his subjective satisfaction. Please see under Article 201 or 111.
5645.
Lord, 5664. 5664.
216.
Yes. To test the satisfaction reached by the President, there is no satisfactory criteria for judicially discoverable and manageable standards that what grounds prevailed with the President to reach his subjective satisfaction. There may be diverse, varied and variegated considerations for the President to reach the satisfaction. The question of satisfaction is basically a political one. Practically, it is an impossible question to adjudicate on any judicially manageable standards. Obviously, the founding fathers entrusted that power to the highest executive, the President of India, with the aid and advice of Council of Ministers. The satisfaction of the President being subjective, it is not judicially discoverable by any manageable standards, and the court would not substitute their own satisfaction for that of the President. The President's satisfaction would be the result of his comprehending in his own way the facts and circumstances relevant to the satisfaction that the government of the state cannot be carried on in accordance with the provisions of the Constitution. There may be wide range of situations and sometimes may not be enumerated, nor can there be any satisfactory criteria. But on a conspectus of the facts and circumstances, the President may reach the satisfaction that the government of the state cannot be carried on in accordance with the provisions of the Constitution. Therefore, the subjective satisfaction is not justiciable on any judicially manageable standards. Moreover, the executive decision of the President receives the flavor of the legislative approval. That is something different because that has to go before the House. We are not concerned with this, my lord. I am relying upon this, my lord, to show that multitude of considerations go into the decision making, whether to grant assent, withhold assent, refer it to the president, or resort to the proviso. And one consideration can be to let the situation cool down. Suppose a parliament passes a law, assembly passes a law that except a particular local language, we will not permit use of any other local language. Maybe it is within list 2. And waiting for 1 year may be considered by the governor in his constitutional wisdom to be a wise thing to do. Lord, then kindly come back to my note, my lord. I am not reading any other. My lord. My lord, I have relied upon page 720,
Much more time is required,
10 minutes.
more than 1 hour.
I'm sorry.
Yes, sir,
My
half an hour.
apologies, my lord. Your lordships have been very indulgent, my lord. My apologies to my learned friends also, particularly Mr. Sibal.
So we'll have to compensate that time.
I will.
We will have to compensate. Or you will compensate from your rejoinder, then it's okay.
No. But I will compensate outside the not, my lord. I can't compensate the time, my lord.
Just, if I may just have liberty for a moment.
Hey, what?
I have signed it from.
That's all. My lord, I have cited AK Call. I am not reading it. Your lordships may kindly read it. But please, my lord, come to page 730. Well, on the lighter side, my lord, for the first hour, my lord, we did not start arguments. First hour was on the preliminary issues raised by them. So nobody needs to be compensated. Now we are being compensated for that 1 hour which we lost. On the lighter side. Well, entirely your lordship's discretion, my lord.
So 4 days was including 1 hour for the preliminary.
Your lordships are right. I am saying on the lighter vein, my lord. Your lordships can, my lord, extend time, curtail time. My lord. That's absolutely my lord's discretion. My lord, page 730, my lord, I have cited one British judgment, my lord, which I generally do not cite, but 2 reasons. A, my lord, our writ power is, my lord, prerogative writs as was available in England. And second, our constitution is essentially and broadly framed on the British parliamentary system. My lord, only one paragraph. And my lord, this judgment is cited in India from beginning, my lord, not in a recent time, my lord. From the beginning, and it has, my lord, it is cited with approval of this court, my lord. My lord, kindly see 731. But I do not think that the right of challenge can be unqualified. It must, I think, depend upon the subject matter to the prerogative power which is exercised. Many examples were given during the argument of prerogative powers which, as at present advised, I do not think could properly be made the subject of judicial review. Prerogative powers such as those relating to making of treaties, the defense of realm, the prerogative of mercy, the grant of honors, dissolution of parliament, and the appointment of ministers, as well as others, are not, I think, susceptible to judicial review because their nature and subject matter is such as not to be amenable to the judicial process. Now, my lord, I have given 4 classes. My lord.
But in England, the powers of the High Court are much restricted as compared to the powers of our High Court. And
Correct, my lord. Correct. They cannot even go into the question of validity of a law.
validity of a law.
I am on a limited point. Then there are certain prerogative functions of co-equal constitutional functionaries which would not be subjected to prerogative writs by the judiciary. My lord, that is what, my lord, this judgment says. My lord, your lordships would be guided. My lord, that's my respectful submission. My lord, by these 4 factors which I am not reading or elaborating, the authority, which authority the government is exercising under Article 200. What are the nature of its functions? Second is nature of the function. Third is the stage of the process. But your lordships are, my lord, as my lord held in the judicial view taken by the division bench, there is a permissible approach to Article 32 or 226 at a stage where the bill is yet to become law. If you come here, the withholding is wrong. Grant of assent is wrong. Referring is, even reference to the president is wrong. Reasons are not given. Reasons are unnecessary reasons. That's what, my lord, the view has taken. That view, your lordships may have to say correct view or a wrong view. Then constitutional choice in Article 200 is not binary. My lord, I have said, my lord, distinguishing it from Article 356. It's not that whether to appoint president rule or not to. There are several choices and multitude of contingencies to be kept in mind. My lord, one judgment, and I'll read only one part. My lord, somebody came here that criminals should not be inducted into the ministry. My lord, this honorable court, my lord, has said this at page 733. It's a 5-judgment judgment, Manoj Narula. Thus, while interpreting Article 75(1), definitely a disqualification cannot be added. However, it can always be legitimately expected regard being had to the role of minister in Council of Ministers and keeping in view the sanctity of oath he takes, the Prime Minister, while living up to the trust reposed in him, would consider not choosing a person with criminal antecedents against whom charges have been framed for heinous or serious offences, etc. And last, rest has to be left to the wisdom of the Prime Minister. We say nothing more, nothing less. My lord, this applies with equal force to the Honorable President of India and the Governor of. Then your lordships may kindly come to, my lord, Khera versus Shergill, page 734. I'll read, my lord, only the highlighted part at 734. My lord, immediately after citing, my lord, New Zealand judgment, the distinctive feature, your lordship gets, highlighted part, my lord. The distinctive feature of all these cases is that once the forbidden area is identified, the court may not adjudicate on the matters within it, even if it is necessary to do so, in order to decide some other issue which is itself unquestionably justiciable. Where the non-justiciable issue inhibits the defense of a claim, this may make it necessary to strike out an otherwise justiciable claim on the ground that it cannot fairly be tried. If it is unjusticiable, even connected justiciable issues would also, the court would be refrained from examining. My lord. Your lordships, my lord, the chief got that, my lord?
Yes, sir.
Yes. My lord, Article 361, my lord, this is my last point. Please come to, my lord, page 736. Rameshwar Prasad, my lord, my lord, my lords, perhaps, my lord, indicated, had in mind para 173. Incidentally, my lord, Justice Narasimha appeared, my lord, in the matter. Para 173, my lord. A plain reading, may I read, my lord, page 737, my lord. A plain reading of the aforesaid articles show that there is a complete bar to the impleading an issue of notice to the President or the Governor, inasmuch as they are not answerable to any court for the exercise of performance of their powers and duties. Most of the actions are taken on the aid and advice of Council of Ministers. The personal immunity from answerability provided in Article 361 does not bar the challenge that may be made to their actions. Under law, such actions, including those actions where the challenge may be based on the allegations of malafide, are required to be defended by the Union of India or the state as the case may be. Union of India means President of India and Governor means state. And we are now examining, your lordships are examining a question whether state can file a petition challenging government's action. Then there will be nobody to defend it. Even in cases where personal malafide are alleged and established, it would not be open to the governments to urge that the same cannot be satisfactorily answered because of the immunity granted. In such an eventuality, it is for the respondent defending the action to satisfy the court, either on the basis of the material on record or even filing the affidavit of the person against whom such allegations of personal malafide are made. Article 361 does not bar filing of an affidavit if one wants to file on his own. I have my reservations, but this is the law declared, my lord, by this court. The bar is only against the power of the court to issue notice or making the president or the governor answerable. In view of the bar, the court cannot issue direction to the president or the governor for even failing to assist, filing affidavit to assist the court. Filing of an affidavit on one's own volition is one thing, then the issue of a direction by the court to file an affidavit. The personal immunity under Article 361(1) is complete, and therefore there is no question of president or the governor being made answerable to the court in respect of even charges of malafidis. I'm citing this as a judgment. As students of law, we may have our views. And, my lord, kindly see in the final conclusion, my lord, at page, my lord, 738, para 179, the position, your lordship gets one. The position in law, therefore, is that the governor enjoys complete immunity. The governor is not answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in exercise and performance of those powers and duties. The immunity granted by Article 361 does not, however, take away the power of the court to examine the validity of the action, including on the ground of malafidis. But again, this was not in the context of his legislative function under Article 200. In a matter where he cannot be even defended by the state and will not be defended by the state. My lord, in Nabam Rebi, I am not, my lord, reading that judgment, the governor was issued notice. Lord, it was pointed out that 361 is immune. Well, this is a 7-judge bench judgment. The court withdrew the notice issued to the governor. That no, it was a mistake. We should not have issued notice to the governor. Lord, kindly come to my lord.
But he appeared on his own and filed an affidavit.
That's what the judgment also said. In his own volition, he can come.
That is, exactly 2 minutes back, I read that. Exactly 2 minutes back. And both of us appeared, we know that happened. So this social media and reels have created a problem. I'll my lord, proceed further, my lord. Please come to my lord 741. And this is my last submission, my lord. Para 41. It is submitted that the judicial pronouncement interpreting Article 361 was in the context of an action of the president or governor not relatable to either Article 111 or Article 200 or 201 of the Constitution. The cases decided by this honorable court held that government can answer on behalf of the governor. In practice, the secretary to the governor is joined as a party so as to enable the court to seek the record from the office of the governor to satisfy itself about the existence of material, procedure, etc. But in case of executive functions, here material may be available, but the satisfaction, which can be in the form of grant of assent, which can be in the form of withholding of assent, reference to the assent, or reference to the house. Lord, kindly see the devastating consequence. Suppose the governor refers it back to the house, and if 226 is maintainable, some private citizen will come that why it was referred to the house. Lord, would the honorable court, I'm posing a question to myself, start examining pre-enactment actions of the constitutional functionaries? Which is precisely, my lord, the law which is laid down. Lord, therefore, my lord, my submission is neither 32 is maintainable or 226 at the behest of the state. Number 2, even at the behest of private individuals, they are not justiciable questions, and therefore 32 and 226 would not be available, and 311 would also not, 131 would also not be available, my lord, because it is not Union of India and the state or between two states. My lord, I have cited, my lord, BP single judgment, my lord. Because BP single, my lord, 5-judge bench says that, my lord, I'll just note the para, my lord, they are not agents of the Union of India. That's what, my lord, 5-judge bench has said. 7904
The Union government end of the.
My Lord, para 40. I'll just read, my Lord. Please note the para, page number 7904, BP single, volume 5.20, page 7904, paras 40. He is not an employee of the union government.
Page number?
7904.
Volume 5 and 14.
Yes, my Lord.
20.
5.20, my Lord.
What are the parties' name?
My Lord, BP single versus Union of India. Lord, para 40. But it says, my Lord, he is not an employee of Union of India or agent of the party in power. Lord, para 40, I'll read, my Lord, read it fully. It is thus evident, your Lordship gets on. I'm sorry, my Lord, just a second.
Yes.
It is thus evident that a governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of his council of ministers. The second is a function as a vital link between union government and the state
that's what
government,
I was
which
saying.
my Lord the Chief Justice were indicating. He is a link and the state government. In certain special or emergent situations, he may also act as a special representative of the union government. In special my Lord, situations, he is required to discharge the functions related to his office, different roles harmoniously, assessing the scope and ambit of each role properly. He is not an employee of the union government, nor the agent of the party in power, nor required to act under the dictates of political parties. There may be occasions when he may have to be impartial or neutral umpire where the views of union government and the state government are in conflict. His peculiar position arises from the fact that the Indian constitution is quasi-federal in character. So, my Lord, if governor cannot be joined, governor cannot be made answerable, and it's a issue between union and the state, my Lord, I'm putting a question to myself, my Lord, who will defend the governor? If the law is right that if he doesn't do it, come to us. If the president doesn't do it, come to us. And they will have to do it in this fashion. My Lord, these are my respectful submissions. I'm really grateful for the indulgence. It was an indulgence, my Lord, given, my Lord, by your lordship. So much.
I'll just take a moment, Lord. Our understanding was that this issue was not being addressed, but we have, as state of Andhra Pradesh has filed a 32 Lord. Therefore, I would reserve my rights to seek instructions, Lord, if my Lord may permit at the end, I may just respond.
State of Andhra has filed 32.
There are 30, not some other issue, Lord. It's a surface issue. It's not an issue. Because in para 13,
Better take instruction.
para 13, the SG's submission is broad-based. 14 it qualifies it, 60 qualified, but 13 the submission.
I'm saying
is broad-
202, 201.
I'll have to take instructions. I'll have to take instructions on it. That's all. I'm not saying I want to respond to it, but I'll have to take instructions on it. At the end, I'll just ask your lordship for maybe a few minutes.
It's a proposition of law. I'm not on Telangana, even Madhya Pradesh, Rajasthan, Maharashtra, nobody can file. State of cannot file it. That's all.
You would have to take instructions as to
Certainly.
what is the stand of his case.
The issues, but we are endorsing and supporting the stand of the AG and the SG. Not this is the only.
Yes, certain.
You have seen the timetable, there are, in some states, there are 2 to 3 councils. We have, on this side, we have.
That maybe if we have, my Lord,
1 minute, yes. We have, when we are saying something,
I'm
we don't expect,
my apologies.
when you object to his,
No, I'm sorry.
in their case, we did not allow more than 1 council per state.
State.
In so far as the other side is concerned, we did not permit more than 1 council to appear for 1 state. So we will have to make a choice.
Lordship will follow the same.
In case of some states, they have given names of 3, 4.
That will be adjusted. I'll try and work it out in the lunch first. I'll
Yes, sir.
work it out in the lunch.
They will have to choose whoever
I understand.
wants to represent.
Work it out in lunch.
This both will have to sort it out.
Wait, please do, my lords. Well, as my submissions, your lordship will find in volume 2.2, starting, I am told, at 470. Open it here. The actual submissions start from 480. The rest is an index.
Volume 2.2.
Volume 2.2,
Volume 2.2 starts from
Volume Roman 2.2, PDF का page अलग होगा.
PDF, you are telling the PDF page,
No,
running page.
no, running page, running
copy.
page.
Volume Roman 2.
Well, this is it, the way it looks like. Running page is given by lordship.
Yeah.
Roman 2.2.
Right, will you be here? Will be here.
The link is there, right?
It's on the link also, well, it's a hard set also. It actually starts at 480.
Yes.
When your lordship starts using it, your lordship may do me the favor of using the second page on the right side rather than the big page. It'll be easier. When your lordship uses it, lordship will use the smaller page when your lordship uses it, but I mean just for convenience. Let me, well, let's tell lordships in 2 minutes the structure and the sequence. The 3 bigger issues I'll be dealing with. The first, which well starts with page 480, that is page 1, is about the whole concept of discretion, the lack of it, the degree of it, etc. between in 200, Article 200. So that's the broad discretion point. That is Balad's, I think, up to pages 61 to up to 63, the smaller page 63 of my submissions. It deals with questions 1 and 2. So discretion is a lordship's presidential reference questions 1 and 2. I will then deal, Malus, with questions 3, 4, 6 and 9 collectively, which is broadly judicial review, oblique justiciability, oblique supremacy of judiciary, etc., etc. That will run from 63 to 103. And all of us quotations really, because rather than take a lordship to the judgment, the relevant lines are underlined and quoted, as Mr. Mehta has done. The third broad issue, Malas, I'll deal with is the timelines, which will be from page 104 onwards in detail. And then, Malas, I'll deal very briefly with the relatively more subsidiary issues, which is question 8, 10, 11, 13 and 12. That's clubbed together towards the end of the submissions. What I have done, Malas, in structure is that on each head, for example, I'm starting with discretion. I've summarized everything I want to say on that in 2 pages in the beginning to give your lordship the sequiturs and the consequences. And the rest is an elaboration of that broadly in the same sequence. So now, Malas, your lordship will turn to 200, which is at page 1, which is page 480, the longer page. Your lordship will use the smaller page.
Page?
480, my first head starts, Malas, discretion and Article 200. And in that, Malas, in the beginning, I have given in 2 pages all the summary points, 7 points in summary of what I'm saying on discretion, just summarizing the propositions.
Left it with me.
Willis, the summary is this. First, Willis, I will deal with the fact that the governor and the president, I'm reading para 2, Willis, at page 1, are titular heads functioning within a federal parliamentary form of government, bound by their respective state and central council of ministers, with no discretion as to executive decision making, save and except where so explicitly conferred by the Constitution, that too in a few rare cases.
What about 163?
Fully dealt with once. That's fully dealt with. I'll make good that. And in each system, this is the pattern I'll follow in each, and under each also, CAD first, some case law then, and the first principles. That's directly 163, 162 will be dealt with. Now the para 3 and 4 are interlinked in an interesting way. I am going to say, Melis, that there is strong material as per para 3, give me a minute to oralize, that in each of the three options in Article 200 opening, in each of the three, the governor is bound by the advice of the ministry. In returning back also, and in referring to the president also. And there is material strongly to suggest that. But I immediately after that put para 4, that without prejudice, in the alternative, I have argued fully on the basis that in option 2 and option 3, he is not bound in the first time. But you also will see the material in the para 3 will show that the intention was even for the Council of Ministers to bind him and guide him when he refers his back, how to refer back, when to refer back, if to refer back, and also to the president. But that is not necessary for me to maintain my argument because I put para 4 after that. Let me do 3 and 4 now. There is strong material, especially in Shamsher and Nabam, as also in the last at least 3 speeches in the Constituent Assembly, respectively by Dr. Ambedkar, Mr. Krishnamachari, Mr. Brajeshwar Prasad, to conclude that all the 3 options exercised by the governor under 200, namely, first is assent to a bill, withholding assent or reserving the bill, are intended only to facilitate lawmaking by the Council of Ministers, and therefore each of the 3 options subjects the governor to the binding aid and advice of the Council of Ministers. This is expanded in pages 29 to 44. They are the internal pages, the smaller pages. However, without prejudice to the previous paragraph, and apart from and distinct from it, the governor in any event, has only 3 options, and if he chooses not to assent to the bill, he may, even without being bound by the aid and advice of the Council of Ministers, either return the bill to the State Assembly once or refer it to the President when the governor first receives the bill, assuming he has discretion to do that without being bound in those 2 cases. 5th is there is no so-called 4th option of making the bill fail or fall through. I'll be showing a phrase, 2 words are plucked out completely out of context, completely. And how this one fall through theory, or as he calls it, withholding asset simpliciter, negates the whole of 200 and the first proviso, liquidates it. Then para 6. Nor is there any 5th option. So 4th option is not there. Nor is there any 5th option of sending the bill for presidential assent after having first exercised the 2nd option of withholding assent, returning it to the State Assembly and receiving it back from the State Assembly under the regime of the first proviso. Actually, and the debates are very interesting on this, whenever they talk of the governor's discretion in other articles, which your Lordship knows well, some articles he's given discretion by the Constitution, they cite 200 only for the 2nd proviso. The governor has a discretion in Article X, in Article Y, which we all agree, there's no dispute. Some judgments, when they cite those articles, club 200, specifically qua the 2nd proviso, which we all agree also, specifically gives the governor discretion. That too subject to the words qua the High Court, not general.
Subject to?
The words given qua the High Court. 2nd proviso. So that discretion envisaged in the whole of 200 is actually only envisaged limited to 200, 2nd proviso. Only. Which has been misread and with great respect is distorted in submitting that he has discretion generally under 200. Now this is the entire summary of my first part. And this runs from up to page 63. All quoted at one place. Let me start with the first part, para 8. The Constitution of India envisages a parliamentary form of government. That one I will skip. Para 8.1, while the executive power de facto lies with the Council of Ministers, the executive power is formally expressed to be taken in the name of the governor. Thus, the executive powers are wielded by the Council of Ministers. Then was 8.3. The governor does not have any independent discretion in the discharge of their constitutional functions. This is in consonance with both democracy and federalism, and indeed basic structure, which has been held part of basic structure. Whereas the former president called it friend, philosopher and guide, quoting from Pandit Thakurdas Bhargav. He was quoting Malas, he was not saying it himself. My submission is that according to me, the governor shall be a guide, philosopher and friend of the ministry, as well as the people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions, and some will be such as will be expressly referred. He will be a man above party, and he will look at the minister and government from a detached standpoint. He will be able to influence the ministers and members of the legislature in such a manner that administration will run smoothly. In fact, to say that a person like him is merely a dummy, an automaton, or a dignitary without powers is perfectly wrong. Because previous things have said he has a role. He's not a dummy. It is quite right that so far as our conception of a constitutional governor goes, he will have to accept the advice of his ministers in many matters. There are many other matters in which the advice will neither be available nor will be bound to accept that advice. This is Pandit Thakurdas Bhargav. Now let's come, Malas, going back from the beginning. Dr. Ambedkar.
He also recognizes that in some matters he will.
Which are
bound by the aid and
the
advice of the
expressly conferred. There's a whole list I've given.
And in some matters he may have discretion.
Some matters he'll be having a
We have
discretion.
to read 200 along with 163.
Therefore, when they say that you have discretion, of course he has discretion. In 5 or 6 listed articles, which I'm going to deal with, one of them is 200, only quay the second proviso. There is no discretion prior to that. If you read it against me, as I've given in the alternative argument, he has one discretion that first time he can refer back or first time he can refer to the president. If you call that discretion. In fact, it's very interesting, but it's not told to your lordships. The 35 Act had a discretion in both the opening words of the counterpart of 200 and in the provisos. Then first round, in the debates of the assembly, they removed the word discretion from the opening part. Then again there were fights on the word discretion. Then in the second part they removed the discretion of proviso also. And Dr. Ambedkar comments why. Clear pattern. Idea was to give you discretion only in the second proviso. Therefore, whenever your lordship finds discretion mentioned, 163, 1 and 2 are not blanket provisions. They say they are except in so far as the Constitution says. And the Constitution gives you I've got a list of provisions, take out the list of provisions. One of the list of provisions is 200, but only second proviso. That's the scheme, Malas, I want. Now, let us kindly come to Dr. Ambedkar. He, Malas, calls it purely ornamental. These are not my words, the word ornamental. And the selection of the governor would depend upon the personality, status, character, education, and position. Now, kindly read Dr. Ambedkar. It's been said in the course of the debate, argument against election. Speaking for myself, that was not the argument which influenced me, because I do not accept that even under election, there'd be any kind of rivalry between the Prime Minister and the governor. For the simple reason that the Prime Minister would be elected on the basis of policy, while the governor could not be elected on the basis of policy, because he could have no policy, not having any power. Now, this is when they were debating to elect the governor, not nominate him. So he said, I accept that you elect him, even though there's no rivalry.
Still he will have no power.
He will have no power. So far as I could visualize, the election of the governor would be on the basis of his personality, even if you are electing him. Look at it, he has no power even as the elected person. Is he the right sort of person by his status, by his character, by his education, by his position in the public to fill in the post of governor? In the case of the Prime Minister, the position would be, is his program suitable, is his program right? There could therefore not be any conflict even if we adopt the principle of election. Dr. Ambedkar is very clear, because to say this when you're talking of election is to have a clear clarity about what a governor is in terms of powers. The other argument is, if we are going to have a governor who is purely ornamental, is it necessary to have such a functionary elected at so much cost and trouble? So from being ornamental, he goes to only nomination. Why spend money on elections? Then Malas, page 5 middle. In my judgment, there is no fundamental distinction between the second alternative and the amendment itself. The second alternative suggested is also a proposal for nomination. It is a variant, Malas, or nomination with some conditions. The only thing is that there are certain qualifications, namely that the president should nominate out of a panel elected by the provincial legislature. But fundamentally, it is a proposal for nomination. In that sense, there is no vital and fundamental difference between the second proposal proposed by the drafting committee and the amendment which has been tabled by Mr. Prasad. Then the boldface lower down. Well, I'm reading the boldface. I'm not trying to avoid anything. I can always read something we missed out by mistake, but it'll save time if I read the boldface subject to some other parts. I want to warn the House that the real issue before the House is really not nomination or election. Because as I said, this functionary is going to be a purely ornamental functionary. How he comes into being, whether by nomination or by some other machinery, is a purely psychological question. What would appeal most to the people? A person nominated or a person in whose nominated the legislature has in some way participated. Beyond that, it seems to me, it has no consequence. Therefore, the thing I want to tell the House is this. The real issue before the House is not nomination or election, but what powers you propose to give to your governor. If the governor is a purely constitutional governor, repeatedly the entire approach is that, Willis. That's why we are called a parliamentary democracy, with no more powers than what we contemplate expressly to give him in the Act. The express power is a proviso of 200, second proviso, and some other provisions. Don't say 28, just keep it open here. If the governor is a purely constitutional governor with no more powers than what we contemplate and has no power to interfere with the internal administration of a provincial ministry, I personally do not see any fundamental objection to the principle of nomination. Then I skip the middle para, Mr. Chaudhary, come back to Dr. Ambedkar next para. Well, that power an elected or a nominated governor will have. If he happens to call the wrong person to form a ministry, that's the question Mr. Chaudhary asked. What will happen if he calls the wrong person? He will soon find his cause that he has made a wrong choice. After 3 or 4 lines. That is not the aspect of the question which is material. The aspect of the question which is material is this. Is the governor going to have any power of interference in the working of a ministry which is composed of a majority in the local legislature? If that governor has no power of interference in the internal administration of a ministry which has a majority, then it seems to me that the question whether he is nominated or elected is a wholly immaterial one. Then, Malas, 3 lines later, they should bear in mind this question. What are the powers with which the governor is going to be endowed? Ornamental. Nothing except a constitutional status. That power, I submit, is not before us today. We shall take it up at a later stage when we come to the questions of 200 and 188. Well, as 188 is wrongly, well, what happened was 188 ultimately dropped, never came in any reincarnation. It was found similar to 287, which is 356. But 188 and 287 were overlapping. Ultimately, 287 became 356, 188 went away. 175 is the present 200. The House should be careful and watchful of these new sections that will be placed at a later stage. So 200 is yet to come. He says that and ends that part. Then next page 8 is Dr. P.K. Sen. Now he confesses that he changed his view. Earlier he had a different view. Now I have a different view is what he says. I must also confess that I am one of those members who have changed their views. What is the change, Malas? Come to the middle of page 8. Since then, on sober and serious reflection, evidently, the members of the House are now persuaded that a general election of that kind, whereby the governor was to be elected by adult suffrage, would impose a tremendous strain upon each province and would hardly subserve the purpose for which it was being held. What is the purpose? The upholding of democratic ideas. The question is whether by interfering, so because democracy itself is the basis when you change him from a non-executive governor to any executive role. Democracy itself is at stake. The question is whether by interfering, the governor would be upholding the democratic idea or subverting it. It would really be a surrender of democracy with 2 swords in one scabbard. That is the antithesis of democratic functioning by an elected chief minister. You should not do anything by implication or interpretation which will make it two swords in one scabbard. It would make it impossible for the Premier or his Council of Ministers to initiate measures which would be in the best interest of the province. Only in exceptional cases of emergency should he have the power or the function to step in.
If there's a provision.
It would make it impossible for the Premier or his Council of Ministers to initiate measures which would be in the best interest of the province. Only in exceptional cases of emergency should he have the power or the function to step in and interfere with the actual governance of the province for a short time. 356 came down the line, that time it was 188, became 287, etc., etc. Of course, the condition and circumstance is such. Therefore, in the best interest of democracy, in the best interest of parliamentary form of government, which has been decided upon the basis of the draft constitution, the election of the governor by adult suffrage is uncalled for and inappropriate. The next method of election that is suggested is election by the legislature. There also there is mischief, only in another form. And a conflict would arise between the Premier and his Council of Ministers on the one hand, and the governor and certain other sections of factions which would be in his support. Therefore, I believe that it would, instead of being in the interest of parliamentary government, be a thorn on the side of the Premier and the Council of Ministers and would prevent them from carrying out any measures which are in the best interests of the province. Then come to the next page, please. The function that the governor has to fulfill, as it is now borne in upon the members of the House, is that of a lubricator, if I may use that expression. A facilitator is another word, which he doesn't use. He is not to interfere, but he has to just smooth matters. If there are factions, if the different sections of the community are at loggerheads, it is for him to act more or less as a lubricator, a cementing factor. He is to help the machinery of the government, which is in the hands of the Prime Minister and the Council of Ministers. He is not to come and interfere and cause confusion or chaos. He would be the person really to lubricate the machinery and to see to it that all the wheels are going well by reason not of his interference, but his friendly intervention. And this, I believe, is Mr. Sen, who had a contrary view earlier. He says, I confess, I've changed my view. Then, so we've done with the CAD debates. We are only on the general point.
He now supports the view that he should be appointed by the president.
Yes.
On the advice of the area and advice of the central government.
Correct. But on the reasoning that any other alternative will give him a role which he should not have. He's formal, he's constitutional, he's titular. It's in his name that you act. The reasoning is what I've quoted, Wallace. Of course, the debate was elect him like this, elect him like that, nominate him like this, nominate him like that.
Elected directly or elected through by the members of the Legislative Assembly or nominated.
That's right. So this is my first summary still going on, Wallace, on 200, on the first part, about the meaning of, Wallace, this whole discussion.
Powers of the governor.
Yes, powers of the governor. Now, Wallace, we've done with the CAD. Now we come to the case law. First, obviously, Shamsher. Shamsher has held the field for decades, Wallace. It's 7 judges and it's very comprehensive. I'm only quoting those which are relevant to this, on the lines and the thrust of the CAD, of the Constituent Assembly. Under the cabinet system of government, as embodied in our constitution, the governor is the constitutional or formal head of the state. And he exercises all his powers and functions conferred upon him by or under the constitution on the aid and advice of his council of ministers. Now, this is a summary of 163 also, broadly. Save in spheres where the governor is required by or under the constitution to exercise his functions at his discretion. The constitution itself tells you, the text tells you, not some general, omnipresent, omniscient, residual power in the interstices hiding which is inherent in him. No. This court has consistently taken the view that the powers of the president and the powers of the governor are similar to the powers of the crown under the British. It's very interesting, Wallace. They trace it to the crown where it is, I would say, Wallace, it would be horrifying if the Queen ever decided to, Wallace, do any of the things which we are having sometimes now. But just note on the side, it will come later. In my smaller numbered page 28, I have given in para 13.4 a list of those specific powers of the Constitution. Lordship, note on the side only, it's coming.
Page?
Well, at page 28, the smaller page, para 13.4, I have listed Article 167, if the governor so requires, 200 proviso second, 356, 371A. There may be more. I've given an illustrative list only. Schedule so and so. Please come back to para 28. I have my small page 11. Please come back to 11.
Yes.
This court has consistently taken the view that the powers of the president and the powers of the governor are similar to the powers of the crown under the British parliamentary system. And so many cases are cited. Turn the page. Ram Javai, that famous case, fellows. Then next page. The initiation of legislation, the maintenance of order, the promotion of social and economic welfare, the direction of foreign policy, the carrying on of the general administration of the state are all executive functions. The executive is to act subject to the control of the legislation. The executive power of the union is vested in the president. The president is the formal or constitutional head. The real executive powers are vested in the minister of the cabinet. There is a council of ministers, the prime minister is the head to it. I'm very sorry to say there is a para in Mr. Tushar Mehta's submissions. I'll read that para. Where many of these very things settled by Shamsher years ago, he says the governor may have to hold a bill back because he has to consider these things. And I am assailing that para for another reason. Doomsday scenarios are given. 9 doomsday scenarios which have not happened happily in 75 years of our republic. A state says only Tamilians can enter the state. A state says only local language can be used. Hypothetically, the sky may fall on our heads, bills. My lords have very evocative passages that please don't judge, especially constitutional adjudication, by disaster scenarios. But that para has got 9 examples which are unheard of, unthinkable. And happily, with all the distortions of our democracy in 75 years, have not happened in 75 years here. So they are very imaginary, and the imagination is febrile and fertile. Now let us come back to page 12. The provisions of the Constitution, which expressly require the governor to exercise his powers in his discretion, are contained in articles to which reference has been made. To illustrate, 239, now this is the example Lordship was asking where they are given the power. The governor is given power by the Constitution. To illustrate, Article 239 states that where a governor is appointed administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. Now, let's just see. This is Shamsher, which is why what is happening is in some paras of other judgments, they quote the same thing as a general 200 without saying second proviso. And then it is used by the government to say that it is general discretion in 200. Shamsher correctly says that they are talking of the second proviso, where of course there is discretion.
When the governor of Punjab
Yes.
is also an administrator for the city of Chandigarh. So for Chandigarh, he would not be bound by the aid and advice practice.
And the
Council of Ministers.
and look at our constitution, famous fellows, they foresaw it, whether then or now in 239. Obviously, it created a ridiculous situation, but my Lord Chief Justice is giving an example. They should not have it, therefore, correctly. So they thought of it, they gave it. Now, the second part is what interests me. Just come to the second part of the same para. My Lord is on page 12. The Honorable Chief Justice mentioned this. Just come to the lower part of page 12. Again, Article 200 requires the governor to reserve for consideration any bill, which in his opinion, if it became law, would so derogate from the powers of the High Court so as to endanger the position which the High Court is designed to fill in the Constitution. This is the second proviso which has discretion. And I was just pointing out the error when my Lord the Chief Justice gave that example. In many judgments, 200 is mentioned as an example of discretion, but some judgments, few of them, Don't add the subsequent words which Shamsher added. And that is used to say your general discretion. This is the discretion which is in 200. 200 is one of those articles where the governor is given discretion. It is part of my list of 167, 239, etc. But only the second proviso. As the Lordship said of Chandigarh, governor can't allow the High Court to be tinkered with like this. So the Lordship thought of it and put it there. Next paragraph, page 13. In making a report under 356, the governor will be justified in exercising his discretion even against the aided advice. Another example, because 356 says so, there's no question of seeking the aided advice of the government, of state government, to dismiss the state government. There is no question. Now see the last part of that page 13 minutes. In all other matters where the governor acts in his discretion, he will act in harmony with his council of ministers. The constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of the council of ministers. And the previous lines I have not underlined to save time are all saying he must act at the aided advice. They say again and again. Now, I had read para 54 above at page 12. My Lord has noted page 12, para 54 I have quoted of Shamsher. 2 paras later, they say the same thing in para 56, but they don't use the suffix of the second proviso. So my learned friend says that what is clarified 2 paras earlier in 56 means you have general discretion in 200. I hope I'm clear with this. Now come to 56 at page 13. Similarly, 200 indicates another instance where the governor may act irrespective of any advice from the council of ministers. In such matters where the governor is to exercise his discretion, he must discharge the duties to the best of his judgment. The governor is required to pursue such courses which are not detrimental to the state. Just a para before that, which is quoted at page 12, they were discussing examples which included a second proviso of 200. This has to be read in that context. It is not an independent source of, otherwise Shamsher for the last 40 years would be read as an independent source of discretion for the governor. Shamsher, your Lordship, cites for every presidential discretion, every governor discretion. If this para is led literally to mean that 56 is not anchored in or relatable to 54, then he has complete discretion. It can never be. Nobody is rated like this till now. Nobody. Then page 14. For the foregoing reasons, we hold that the president or the governor acts on the aid and advice of the council of ministers with the prime minister at the head in the case of the union and the chief minister at the head in the case of the states in all matters, which vests in the executive, whether those functions are executive or legislative in character. Neither the president nor the governor is to exercise the executive functions personally. This is Shamsher, 7 judges, 40 years ago. More than 40 years ago. The present appeals concern, ignore that. Now let us come to Justice Krishna Iyer, not only for the language, but for a very fundamental concept he raised. He said this cuts at the root of our democracy. If you start recognizing the governor as having discretion, he takes it to democracy level, and basic structure. Please see that. Same page 14. Thus vindicating our democracy instead of surrendering it to a single summit soul. Single summit soul is a governor, whose deification is incompatible with the basics of our political architecture, lest national elections become Dead Sea fruits. Legislative organs become labels full of sound and fury signifying nothing. And the Council of Ministers put in a quandary of responsibility to the House of the people and submission to the personal decision of the head of state. This is not fully strong Krishna language, not difficult to understand, and also is lyrical. A parliamentary style republic like ours could not have conceptualized its self-liquidation by this process. I think it's a very, very pithy sentence, and very effectively put. Some parts of this Krishna sometimes make us want to go to the dictionary or to Mr. Shashi Tharoor. But this is not so. This is the truth, fellas. There are now, I believe, actual classes which my colleague is doing on this. Difficult words thrown to him and he finds a way out.
One of the learned judges in Kerala follows this.
Yes, well, I heard that.
This is Javan Ramjas.
This is simpler Krishna Iyer, J, and very effectively Pithimans. Next para. We declare the law of this branch of our constitution to be that the president and the governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in a few well-known exceptional situations. Without being dogmatic or exhaustive, these situations relate to one, the choice of the Prime Minister. So now your Lordship is spelling out broadly the areas where there has to be discretion. Suppose the House is being dissolved or somewhere the majority is lost, obviously he'll have discretion. You can't be bound, Malas, by those situations. By paramount consideration, would command a majority. The dismissal of a government which has lost its majority but refuses to quit office. The dissolution of the House where an appeal to the country is necessitous. Although in this area, the head of the state should avoid getting involved in politics and must be advised by his Prime Minister, bracket Chief Minister, who will eventually take the responsibility for the step. We do not examine in detail the constitutional proprieties in these predicaments, except to utter the caution that even here, the action, even here, Malas, even here, where he does have discretion, the action must be compelled by the peril to democracy and the appeal to the House of the country must become blatantly obligatory. Now, Malas, is another interesting example of royal assent, where there is the minimal zero discretion. They give that example. We have no doubt that D. Smith's statement regarding royal assent holds good for the president and the governor in India. Refusal of the royal assent on the ground that the monarch strongly disapproved of a bill or that it was intensely, mark the word, monarch strongly disapproved of a bill. According to Mr. 5 paras of Mr. Mehta's written submissions, he can judge security, friendly relations, need, calm down, cooling period, political considerations, everything he can judge. And 50 years ago, 7 judges said this. 50 years ago. Or that it was intensely controversial would nevertheless be unconstitutional. Refusal of assent, even though it's intensely controversial,
This is two judge.
and he disapproved.
What you are reading is two judge.
Yeah,
Yes, Krishna.
I stand corrected. This one is there, this is there. Very well. 2 judges held the field for many decades. Perhaps my laws may want to change it. I don't know. Your Lordships can. No, just check up. Let me check up. Is it
a minority view?
is it part of this?
No, it's not.
Concurring. Let me just check up. I want to be sure. What happened was, Malas,
Justice Ray, Chief Justice Ray was with Justice Baird, Justice Matthew, Justice Chandrachud, Justice Allegance. 5, but both.
so I stand recorrected in my favor. And Mr. Mehta should stand corrected also in his error.
Sentence of Potomac and Thames comes to this.
Yes, Potomac and Thames is here, isn't that? That the waters of Potomac, not the Potomac, but not the Potomac and the Thames, but the Ganges should fertilize. That part is also in this. But Palas, I was just going to check up. This is all part of the concurring. But I'm sorry, just give me a minute. Just turn to, they are taking it that we make it akin to refusal of royal assent. And in royal assent, D. Smith was one book, Wade is the other book. Much before Malas, in the old days in England, they have said that even if he's intensely controversial and he strongly disapproves, even then, if he withholds assent, it's unconstitutional. I will read the para of Mr. Mehta where he says much more. He actually in that para makes the governor holding the departments of national security, foreign affairs and a few other departments. I will read that para. It's not me. Take out that para first. Don't do this. Yes. Your Lordship may want to note, because we have done the extracts, please note in volume V 5.7, just for your Lordship, was the correction on the interruption by Mr. Mehta. There should be a correction on that. In V.7, 5.7, page 2912, the actual SCC, Krishna Iyer J. and on behalf of himself and Bhagwati J. concurring. My learned friend Mr. Gopal Subramanian is absolutely right. Then they go on, Malus, the concurrence goes on. The only circumstances in which the withholding of the royal assent might be justifiable would be if the government itself were to advise such a course. If you do not try to distort the constitution, everything falls into place. If you want to achieve a preconceived result, then you'll be distorting. A highly improbable contingency, or possible if it was notorious that a bill had been passed in disregard to mandatory procedural requirements. Since the government, the latter situation with the opinion, etc., that's not relevant for us. So this is, well, some share, 7 judges. Now come to Navam Arabia. My learned friend wants me to read what is not quoted by me. My learned friend just wanted me to read one para which is not quoted by me. The very first para of the judgment of Justice Krishna Iyer, where he starts. Lordship will not pick up, just note the reference, volume V7, page 2912. Just I'm reading it, need not take the V7, 2912. These two appeals by a couple of small judicial officers whose probation has been terminated by orders of concerned ministers in conformity with the recommendation of the High Court have projected constitutional issues whose profound import and broad impact, if accepted, may...
Which para are you reading?
Opening.
I'm sorry, 2912 or V7, 5.7 or V7. Some of the greatest cases are made from very small litigants with small grievances. This is one such case. But the judges pick up the larger import, howsoever small the case is. And Justice Krishna Iyer, with his usual felicity, formulated the issue. Have projected constitutional issues whose profound import and broad impact, if accepted, may shake up or reshape the parliamentary cornerstone of our nation. And it did, Shamsher has reshaped because it stood the ground. Great deference and complete concurrence would have otherwise left us merely to say we agree to what has fallen from the learned Chief Justice just now. But when basic principles are assailed with textual support, academic backing, and judicial dicta, speech, not silence, is our option. That's his justification for having a concurrence. Then the later parts I've read. Thank you. Now come to Navam Arabia at my page 16. They said clearly that the apparent executive and legislative powers are in fact not independent powers and are to be carried out strictly on the aid and advice.
You are reading which para?
But I'm now on my page, small page 16.
Yes.
After now Shamsher is over, I'm on Navam Arabia. Now in that page 16 bottom, which is not highlighted perhaps, he explains the above edict is not applicable in situations where the governor is expressly required to exercise his function. The bottom of page 16, Justice Narasimhan.
Yes. After Article 163.
Yes, my lord. The question that will need determination at our hands is whether the underlying cardinal principle with reference to the discretionary power of the governor is to be traced from Article 163 or from 161 or from 163(2). Undoubtedly, I'm on the boldface 5 lines later. Undoubtedly, all executive actions of the government of a state are expressed in the name of the governor. He is in that sense, he is the state. Of course, he is the state. His name is there. Even a lordship ordinary letters come by in the exercise of power under by and under the name of the governor. That, however, does not per se add to the functions and powers of the governor. It is also necessary to appreciate that in the discharge of executive functions, the governor of a state has the power to grant pardons, reprieves, respites or remissions of punishments or to suspend, remit or commute. The governor's power under 161 is undisputedly exercised on the aid and advice of the chief minister. Why, Manoj? The governor has full discretion, you will say, because they say the governor may grant pardon. Tomorrow you will argue he has full discretion. The governor's power under 161 is undisputedly, the governor has power to frame rules for the convenient transaction of executive business. This instant responsibility is also discharged on aid and advice. All in all, it is apparent that the governor is not assigned any significant role in the executive functioning of the state. We would also endeavor to examine the duties and responsibilities of the government in the legislative functioning of a state. Well, it's one sentence, I may just digress here. No doubt the governor is part of a legislative process. The word should be process. He is not part of legislation or legislation making. He is part of a process. He is not in any manner a legislature or a legislator. That is clarified by a lordship judgment which I have quoted here in a minute, in a while. Even though Article 168 postulates that the legislature of a state would comprise of the governor, yet the governor is not assigned any legislative responsibility in any house of the state legislature. This is one part which is clear. And on the next page, the governor shall not be a member of either house. Insofar as the legislative process is concerned, the only function vested with the governor is expressed through 200, which inter alia provides that a bill passed is to be presented to the governor for his assent. And its ancillary provision, 201, wherein a bill passed by the state legislature and presented to the governor may be reserved by the governor for consideration. The only exception to the non-participation of the governor in legislative functions is postulated in 213, where he calls and he... So he only, that means everywhere else he is not part of the legislative function. When he has to do an ordinance and things like that, because there is nothing there, he is the executive authority in that sense coming out from the... There he plays a role in 213 and 123 in the central case. The central. The only exception to the non-participation of the governor, only one exception, which apparently vests with the governor some legislative power. The governor under 213 can promulgate ordinances during the period not in session. This function also, is exercised undisputedly on the aid and advice of the council with the chief minister as the head. You may have a role, but it is on the aid and advice. Then, next page. The same thing is. Again they repeat, at page 19. Page 19 they repeat. All in all, it is apparent that the governor is not assigned any significant role even in the legislative functioning of the state. Now I go to para 148. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions and would assign to him a dominating position, kindly mark those words, over the state executive and the state legislature. The interpretation placed on 163.2, and this is all dealing with both 1.1.
That is what I was asking the learned solicitor from the beginning.
What more domination will you have if you are able to do all the things which the written submissions say you can do? Forget domination, he becomes exclusive authority. Kindly see, your lordship will be distorting the whole scheme for decades. This is only saying a dominating position. That's a very mild word, I would say, compared to what the submission, written submission suggests that you can. I am very sorry to say. It's all right, we are making all that. I, was hearing on VC. The submission is also that a referral back or a refusal can include a money bill. Specific argument was made. I went back to the constitution, but I actually spent 15 minutes. I told my learned friend also. I said, I must have misread something. The answer given to support that argument was that no, it will be so. It was, that argument was made and stuck to. But it was supported by reference to 207. I again examined 207. 207 is a very interesting provision, we have on Fridays in Parliament and in legislature some particular day to let off steam. We have private member bills. Friday afternoons are normally kept in most places for private members' bill. They can bring any bill, they let off steam. At the end, either they withdraw or they get an assurance from the government that we will look into it. Nothing. There are only about 5 private member bills which have been passed till now, I think, in the entire history. And that too by government adopting it. Now, 207 was enacted that for a financial bill, you cannot have a private member bill. You must do it only with the recommendation of the state. That provision is cited to support that the governor can return a bill which is even a money bill. That's coming later. It's in sync with the submission that the governor is in he's not a dominating position, he's a super chief minister. Possibly trenching beyond super chief minister also. Now kindly come back. The above position leaves no room for any doubt that the governor is the dominating position. The interpretation placed on 163.2 on behalf of the respondent is just that effect. Secondly, middle of that paragraph. I'm sorry, my apologies. Because of the following contentions. Firstly, whenever a question arises, whether in discharging a particular function, the governor can or cannot act in his own discretion. According to the respondents, the discretion of the governor on the above position is final, on the above question is final. Secondly, since the provision itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted. According to the respondents, this is exactly the same argument dealt with by Constitutional Bench clearly, makes the governor's orders based on his own discretion immune from judicial review. Now, kindly just give me a minute. I have to go a little slow here. This is where I've stopped now on the full stop, is dealing with those areas where you have given the power to the governor in his discretion. Now the court says that is only those given to you specifically, and even those you are fully subject to judicial review. They are saying 2 points here. Navam Rebia. Kindly read on. Accepting the above position will convert the governor into an all-pervading super-constitutional authority. And they've used dominating just 2 paras earlier. This position is not acceptable because an examination of the executive and legislative function of the governor from the surrounding provisions of the Constitution clearly brings out that the governor has not been assigned any significant role either in the executive or the legislative functioning of the state. The position adopted on behalf of the appellates, on the other hand, augurs well in an overall harmonious construction of the provisions of the Constitution. Even on a cursory examination of relevant provisions, we are inclined to accept the submissions advanced on behalf of the appellates. Then, Malas, the next para starts talking of 140. She was asking this question. I'm reading that also, Malas, about 160, what became 163. It was a draft 143, which became 163. Middle of that page, page 20. The crucial position that is clarified from a perusal of the Constituent Assembly debates arising from the answer to the query whether the governor should have any discretionary power at all. The debates expound that the retention of discretionary power with the governor was not in any way contrary to the power of responsible government, nor should the same be assumed as a power akin to that vested with the governor under the Government of India 35 Act. And from that emerges the answer that the retention and vesting of discretionary powers with the governor should not be taken in the sense of being contrary to or having the effect of negating the powers of responsible government. Significantly, with reference to the governor's discretionary powers, it was emphasized by Dr. Ambedkar. The clause is a very limited clause. This is 163.1, 163.2, everywhere else where is discretion, everything. It says, except insofar as he is by or under this constitution. Therefore, 163 will have to be read in conjunction with such other articles which specifically reserve the power to the governor. It is not a general clause giving the governor power to disregard the advice of his ministers in any matter in which he finds he ought to disregard it. Therefore, I think the fallacy of the argument of my honorable, therein lies the fallacy. In our considered view, the Constituent Assembly debates leave no room for doubt. But this is Nabab Revia now. They were quoting Dr. Ambedkar. This is the text of the judgment. Leave no room for any doubt that the framers of the Constitution desired to embody the general and basic principle describing the extent and scope of the discretionary power in 163.1 and not in 2 as suggested. Then, Malas, they strongly endorse, and there are very clear passages in Justice Punchi's report. In para so-and-so of the Justice Punchi Commission, the observations of Dr. Ambedkar have been highlighted. So there's a full connectivity and there is a seamless sync. There is a harmony in what's happening. Dr. Ambedkar says something, 163 says something, Your Lordship's case law says something, the Punchi Commission says something, all are in the same direction. All. The governor under the Constitution has no functions which he can discharge by himself, no functions at all. This is Dr. Ambedkar Malas. While he has no functions, he has certain duties to perform. And I think the House will do well to bear in mind this distinction. This article nowhere either in A or B or C says that the governor in any particular circumstances may overrule the ministry. Therefore, the criticism that is made somehow enables the governor to interfere or upset with the decision entirely beside the point. Then Wallace they quote, in a very limited field, however, the governor may exercise certain functions in his discretion, as provided in 163(1). The first part of 163(1) requires the governor to act on the aid and advice of his council. There is, however, an exception in the latter part, regard to matters where he is by or under the constitution required to so function. My Malus para, we have given the list of those provisions is
Page 29.
28, para 13.4.
You have given those 6 instances.
Right. The expression required signifies that the governor can exercise his discretionary powers only if there is a compelling necessity to do so. It has been held that the expression by or under the Constitution means necessity to exercise such powers may arise from any express provision of the Constitution or by necessary implication. We'd like to add that such necessity may also arise from rules and orders. So you may have such provision. Thus, the scope of discretionary powers as provided in the exceptions has been limited by the clear language of 2 clauses. It is an accepted principle that in a parliamentary democracy with a responsible form of government, the powers of the governor as constitutional or formal head of the state should not be enlarged at the cost of the real executive. Should not be enlarged at the cost of the real executive council of ministers. The scope of discretionary powers has to be strictly construed, effectively dispelling the apprehension of any that the area for the exercise of discretion covers all or any of the functions to be exercised. This makes the balance perfect. There's no problem with 163 unless you start distorting it. In other words, 163 does not give the governor a general discretionary power to act against or without the advice of his council of ministers. The area for the exercise discretion is limited. Even in this limited area, his choice of action should not be arbitrary or fanciful. It must be a choice dictated by reason, actuated by good faith. We are therefore of the considered view that insofar as the exercise of discretionary powers vested with the governor is concerned, the same is limited to situations wherein a constitutional provision expressly so provides that the governor should act in his own discretion. Additionally, a governor can exercise his functions in his own discretion in situations where an interpretation of the constitutional provision is concerned could not be construed otherwise. So you are compelled to so construe that it must, verse 356, anybody says you must consult for anything, be ridiculous situation. We therefore hereby reject the contention advanced on behalf that the governor has the freedom to determine when and in which situation he should take a decision in his own discretion without the aid and advice of the chief minister and his council. We accordingly also turn down the contention. That whenever the governor in the discharge of his functions takes a decision in his own discretion, the same would be final and binding and beyond the purview of judicial review. We are of the view that finality expressed in 163(2) would apply to functions exercised by the governor in his own discretion as are permissible within the framework of 163(1) and additionally in situations where the clear intent underlying a constitutional provision so requires, namely where the exercise of such power on the aid and advice would run contrary to the constitutional scheme or would be contradictory in terms. Here, Your Lordship is asked to read 200 to nullify 200, the opening and the first proviso. Not to further the constitutional scheme, but to dilute or liquidate it. Now, Mr. Kamath in para 13.1 had moved the amendment to remove this except in so far as. That's para 13.1. He didn't like this exception, insofar as by under the constitution required to access. That's then draft 143, now 163. Mr. Krishnamachari, next para 13.2, opposed it and reassured the assembly that the expression was only a safeguard. And what did he mean? Since independent discretion could be exercised by the governor only under the provisions which specifically require the governor to exercise such discretion independent of the aid and advice. So Mr. Krishnamachari said that your opposition, Mr. Kamath, may not be justified because this is the object. Next page 25.
I think you won't be finishing it in 5 minutes.
I beg pardon?
Yes, yes.
No, certainly. Well, incidentally, I mentioned Mr. Shashi Tharoor's name in admiration.
Beg your pardon?
Just to clarify the record, I mentioned Mr. Shashi Tharoor's name in admiration. No, just before I mentioned, it's not a defensive comment. I mentioned it in admiration, not in derogation. Willis.
We don't know what is the other of the social media.
This is,
You sorted out with the
yes, yes.
timelines. So we won't permit more than one lap.
I'll get the list and just check it out.
3344. Oh.
No. We are not saying. Don't have.
you.